All rise. Hear ye, hear ye, hear ye. The Blount County Legislative Body is now in session with the Honorable Jerome Moon, Chairman presiding. All persons having business with this Honorable Commission, draw near, give attention, and you shall be heard. God save the United States of America, the state of Tennessee, and this Honorable Commission. Reverend Charles Bailey, pastor of Laurel Bank Baptist Church, will lead us in the word of prayer.
God, we thank you for the privilege of living in this great county, in this great country. We thank you for these people and their willingness to serve. You've instructed us to call on you for wisdom. We ask it on behalf of all those that make decisions, that they'll be in the best interest of our people. God, we come to this season of the year with thanksgiving in our hearts for all the blessings. God, you bless us even above and beyond what we could ask or think. And we're so unworthy, but we ask, Lord, that we be responsible, and as you bless us, help us to be a blessing to others. Help us to be mindful of those that are not so well blessed during this time of the year, that we could reach out a hand to help them. Everything we ask you for, we ask in Jesus' name. Amen.
Amen. Heritage High School Air Force Junior ROTC will lead us in the Pledge of Allegiance. Thank you. You may be seated.
I'd like to welcome everyone tonight to the November 15, 2012 Blount County Board of Commissioners meeting. Reverend Bailey, thank you so much for your invocation this evening. And on behalf of the chair, on behalf of the commission, the chair likes to thank the Heritage High School Air Force Junior ROTC for the presentation of colors. This time I'll read the emergency evacuation procedure. In the event of emergency evacuation, alarm will sound. Everyone should exit the building by the way of the nearest stairwell in a safe and effective manner. If the nearest stairwell is blocked by smoke, use the other stairwell. Do not use the elevator. Once you've reached the main floor, follow the exit signs to exit the building and quickly proceed away from the building. Be mindful of others evacuating and of emergency vehicles. This time, the commission, please come to order. Register your presence by voting yes.
You have 19 present, 2 absent. You have a quorum.
Thank you, Mr. Clerk. Commissioner Lambert sends her regrets. She has the flu. We thank her for not sharing. And Mark, Commissioner Hasty has got a work conflict. He's going to do his best to be here this evening. So at this time, the chair will stand for a motion to set the agenda. Mr. Lewis moves, and Commissioner Helton seconds. Commissioner Folks, you're recognized, sir.
Thank you, Mr. Chairman. I would just request that items F3, A through D be considered separately.
There, I see them on the agenda listed separately, but we will note your request, sir. Other discussion? Are the members ready for the question? Vote yes to set the agenda. Vote no not to set.
You have 19 yeses.
The agenda is set as published. At this time, the chair will stand for a motion to approve the consent calendar. Ms. Carver moves. Commissioner Wright seconds. Discussion. Are the members ready for the question? Vote yes to approve the consent calendar. Vote no not to approve.
You have 18 yeses and 1 abstain.
18 yes, 1 abstain. The consent calendar is approved. Moving to agenda item C, public input on items on the agenda. Ms. King, if you'd like to come forward, please. Mr. Clerk, please start the clock only after the speaker has introduced themselves, stated the district they reside, and the item on the agenda.
I'm Linda King with Citizens for Blount County's Future. I live in District 4, and I'm speaking on F1. I'd like to ask you to be cautious when listening to our stormwater director and voting to take property rights away from landowners. During the ad hoc committee meetings and voting process for Phase 1, we found that the Stormwater Department was attempting to possess police powers that would allow their representatives to come on private property at any time they felt there was even the slightest possibility that the owner was not following permit regulations or polluting. They wanted the ability to play Big Brother. The Stormwater Director has, on several occasions, stated that he has written the present resolution based on his interpretation of state mandates. He also said he is setting permit and penalty fees at his own discretion. Well, we don't want the interpretation or discretion of an unelected bureaucrat. We found out during Phase 1 that his so-called mandated information was far from correct. It gripes me, too, when the Stormwater Director comes before the Commission and talks about water pollution, but never mentions that fluosilicic acid, or fluoride as they call it, is being emitted into our soil, lakes, rivers, creeks, and ponds. Every time you wash your car or water your lawn, this toxic waste chemical is released into groundwater and eventually ends up downstream. However, it seems they prefer to talk about soil erosion polluting our waters, as though we'll ever stop dirt from running downhill. When I asked a TDEC representative about this chemical exposure to our water, he actually told me he didn't know what fluosilicic acid was. That says so much for the knowledge of the people who think nothing of wanting control of the land you work and pay for. According to President Ronald Reagan, one of the most important basic principles of Americans is the freedom to own and control one's property. Don't take this basic freedom away from we the people and allow bureaucrats to steal our rights. This is Phase 2 of a land takeover plan. Don't think there isn't a Phase 3 and Phase 4 coming soon. Thank you.
Anyone else wish to address the Commission on items on the agenda? Seeing no hands, we have no business under items D and E. First item of business is item F1. The chair will stand for a motion on item F1, Resolution 12-11004, a resolution adopting regulations to protect water quality in urbanized area of Blount County by prohibiting, suppressing, preventing the contamination of stormwater by grading, erosion, and sedimentation. Mr. Kirby moves. Mr. Kaler seconds. The motion is to adopt resolution number 12-11004. Mr. Lael, you are recognized, sir.
Thank you, Mr. Chairman. Would like to offer an amendment to Section 11, which concerns the inspection of these properties, and I would like to add to that in the beginning, upon documented notification of at least 24 hours prior to inspection, comma, then the rest of the Section 11 follow-up.
Upon documented notification of the property owner.
To the property owner of at least 24 hours prior to inspection.
Prior to. The motion is to amend the main motion by notification of the property owner, documented notification of the property owner within 24 hours of the inspection. Is there a second? Second by Mr. Farmer. Discussion on the amendment. Anyone wish to be recognized? We have other names on the board on the main motion. Does anyone wish to speak on the amendment? Mr. Teague is present. We're currently, right now, we're discussing the amendment to the main motion.
Mr. Chairman, I think it'd be wise for Mr. Teague to come forward because I believe there are several amendments to this motion tonight. And I do think it'd be very wise for him to come forward so he can tell us and give us his input as to each amendment as they are brought forward this evening. That's my question.
Mr. Teague, if you'll come forward, sir. Discussion on the amendment dealing with documented notification to the property owner 24 hours prior to going on the property. Okay, does anyone wish to be recognized on the amendment?
Mr. Chairman, point of order. I believe that there might be several. I know that I'm going to be offering some amendments to this.
That's fine. We eat the elephant one bite at a time, sir.
That was going to be my question, Mr. Chairman, is if we want to do this on each amendment as a separate motion.
That's correct, sir.
Thank you.
Dealing with the amendment on Section 11. Discussion. Mr. Carver.
I do have one question. Having the right to go on someone's property, is that as like a deputy or? Someone brought that to me that gives you like law enforcement rights, or can you explain that?
No, there's no law enforcement rights. It's just the ability to access their property to do an investigation.
Okay. And that's just to see if there is activity going on, or?
Yes, if there's, for example, illegal dumping of some pollutant into a stream, say in the back of the property. To physically walk back there, look, identify, take photos, and leave.
And that would come across by someone making a concern brought to your attention?
Correct.
Okay. Thank you.
Mm-hmm. Mr. Harrison, you're
gonna. It's kind of like correct me if I'm wrong, Justin. It's like a codes inspection, say a wiring inspection, a plumbing inspection. This is a dirt's running down the road and ditches. You know, it's to keep the dirt from getting in the rivers and stuff.
Correct.
Commissioner Merle, you recognized.
I was just going to ask you, like you do inspections right now, what is the average notice that you give to people? Other than 24 hours,
There is no notice that I give currently at this time.
Okay, thank you.
Commissioner Farmer, you seek recognition?
Yes, sir. This is in line with the amendment. Mr. Teague, would it in any way hamper or interfere with your performance of your duties to give 24-hour notice?
I think in some situations it could. If somebody has recently, for example, dumped something in a creek, and I give them a 24-hour notice, once I'm made aware of it, for example, we get an anonymous complaint, that gives them 24 hours to clean up any evidence. I go out and visit the site 24 hours later, I find nothing. I leave. I document that nothing was located at the property during the time, yet as soon as I leave, they could continue with that activity. So yes, I think it could hamper it.
Okay. Thank you.
Commissioner Folks, you wish recognition, sir? Not this time. Commissioner Melton, you seek recognition? Commissioner Kirby, I'm sorry.
Thank you, Mr. Chairman. Mr. Teague, one question's already been asked about. You just go out and do you get call-ins or someone telling you that something's going on from a neighbor or whoever for you to go out and investigate an area?
We get calls like that all the time, yes.
So up to this point, have you had calls? Yes. You've been out and checked things. What actually happened when you went out there and did that?
Well, if it's a residence, I will go and knock on the door and introduce myself, identify who I am and the reason I'm there, if someone is present. Otherwise, I just enter the property, document, and leave, and then contact them afterwards if need be.
So, the amendment on the 24 hours, how much percentage of what would happen if things got straightened out and in 24 hours you didn't find anything compared to what you would find after 24 hours?
It'd be hard to answer. For example, if it's a failing septic system, obviously that can't be repaired in 24 hours. The evidence will still be there. Others where there is illegal dumping, if I give them any identification or any idea as to what I'm going to be there inspecting the next day, I think most people would probably clean up their act real fast. Don't know if they would continue once they know I've been informed and visited the site once. That might be enough to discontinue what they're currently doing. But there's kind of two situations. One being inspecting construction sites. I'm required to do that at least once a month. We've got a permit. I have to go out and inspect. The state requires that. The other situation where I think there's some concern with Section 11 would be just, a private property where there's no construction, no permit issued or anything like that. I just get a complaint from a neighbor or a citizen driving down the road and they see something. So construction sites, they expect that. They know we have to come out and inspect. And we don't make our presence known prior to that inspection. There again, there's things that can be covered up and corrected before we get there.
Okay, I'll ask you one more question. You got complaints on a piece of private property. Would that piece of private property have to be close to a stream, creek, or whatever?
No, not necessarily. Well, we get complaints from all over the county, not just one that has a stream on or near their property.
So this resolution would take care of any property, no matter where it's located in the county?
Well, in regard to this one, it would be for construction sites, which would fall within an urbanized area.
So you don't have to have permission. You have to go to a construction site every 30 days, right?
At least once, yes.
Once
Quite often, it's usually more. Yeah. But for example, this one here might be, somebody that's doing some grading in the back of the property that, they didn't have a permit, or dumping dirt into a stream. May not need a permit, but still they can't do that.
So in your opinion, the 24 hours would hinder you in certain cases?
In some cases, yes, I do. Mm-hmm.
So 25%, 75%, 30%?
25 to 30%, if I was to guess.
So 25, 75.
Correct.
Thank you.
Commissioner Burkhalter, you're recognized.
Thank you, Mr. Chairman. Mr. Teague, I'm just going to say something very bluntly, and I'm very unhappy that we are being presented this less than 60 days from its implementation.
Commissioner,
I'm sorry, Mr. Chairman, I'm out of
please
order.
speak to the amendment.
In Section 11, can we remove Section 11 from this resolution and it still pass muster with TDEC?
I would probably have to ask that question to them.
If
My guess is yes, it probably would, but I don't want to say for sure. That
from what I understand, please correct me if I'm wrong, 90% of this resolution deals with grading permits, correct?
yes, construction sites, yes.
Except for Section 11, which gives you the right to come onto private property who has nothing at all to do with the permit if a complaint's been filed anonymously.
Correct. For example, if there's grading on the property that warranted a grading permit, but they didn't receive one, I get a phone call. Hey, there's somebody grading approximately 3 acres back on their property. Are you aware of it? Then I would need to go out and investigate.
But to answer your question is, but at the same time, somebody else can call in with an anonymous, they're just dumping stuff into their river behind their house, and you don't even have to be grading. And that's a violation as well, correct?
Correct. State and county violation.
The next question that I have is, in Section 11, it says you have the right to remove. That sounds like a taking to me. Can you explain to me the removal of foreign objects and blockages? I mean,
Best example, if trash and debris, I'm not talking about necessarily sticks, but let's say litter, garbage, is blocking a pipe under a county road that's coming from a residence. And if it's blocking that pipe, just physically remove it so water can drain as designed.
what about structures erected on somebody's property? Can you remove those? If it's blocking the flow of the riverbed, do you have the right to remove those structures erected by somebody on their private property?
If it's something that's been erected, I would not, more likely physically not remove it myself. I would contact the property owner, inform them of the situation, what's occurring, the regulations, and then try to persuade them to remove it themselves.
But would you agree that the way this is written, you have the right to remove it without any notice to the property owner?
Yes.
Okay, so you can take and remove without any notice, even if it's a structure that's on somebody's property, if you feel like it's a blockage.
Yes.
Okay, thank you. No more further questions, Mr. Chairman.
Commissioner Taylor.
Mr. Chairman, in regard to your notification of a violation, do you respond to anonymous
Yes.
notices, or do they have to give their name?
No. No.
How does that relate to the TDEC regulation? I mean, I'm speaking from personal experience. I served as an inspector in the city of Maryville for several years, and typically, if someone wants to file a complaint, if they're going to complain, they need to tell who they are.
Most situations, people will, inform us of who they are. Not always. For example, we have a hotline, a pollution hotline that they can call a county number here and leave an anonymous complaint about a situation, and we will go out and investigate that.
You may not be able to tell this, but is there any statistical data to how many of those complaints that are anonymous actually lead to an actual violation of present rules and regs?
Very few. Most of the times when we go out and it's anonymous, they encourage us to come out and look. They make it sound really terrible. We go out there, and sometimes there's not even a situation that I can enforce or enact upon. It's maybe a bunch of garbage bags piled up, or they're not maintaining their property. but they use an excuse, for example, a failing septic system, to get me to go out there in the hopes that I will identify other problems and get the owner to correct that, which I can't address that. So we do get a few of those.
Okay, thank you.
Commissioner French, you recognize, sir?
Are we still on the amendment?
Yes, sir.
Okay, I have comments on something else.
Commissioner Harrison, you wish to speak to the amendment, sir?
Yeah, I always, just back to what we was talking about, the 24-hour notice, and a question first. Say, just to give an example, someone's got a grading, they're fixing to put in a subdivision out here on Little River, and B&R grading goes in and sets up, and they set their fuel tanks right down next to the river, and they start grading and they start changing oil and changing diesel right down next to the river. Well, you go in, what do you, the first time in, do you find them right off, or do you go in and give them instructions on how to correct this, silt fence wise or rock wise or whatever?
First time, if it's serious, it would be just a verbal warning, and then followed up by notice of violation. Typically, I can educate and inform the developer or contractor of what they're doing, and come up with, say, a game plan on to remove that gas or that fuel tank further away from the river and properly store it. So no, first off is a verbal warning.
And then just to add, I don't mean to add, but from what I've seen from being in the grading business, a contractor come in and they may change the oil on a machine next to a river. If somebody's giving him 24-hour notice, they're going to take a dozer and cover that up with dirt before he gets there. So this is kind of what problems are inspectors getting at on-site grading, and it's what this is put in to effect for. It's not to take over somebody's property, it's to protect our citizens.
Commissioner Lael, you recognize, sir?
Thank you. In this process, at this point in time, you do not have to give notice, correct? For an inspection. Okay. What is the general demeanor of the folks that you visit on these surprise inspections? Is there a problem? Is there some antagonistic behaviors involved? Is there a spirit of cooperation and let's settle this issue by the methods you mentioned earlier about negotiating with a person to remove a building or an obstruction or whatever? Tell me how that works. This is one of the thought processes behind this. Two things. First of all, the person does own the property. Therefore, this is protecting their rights to be notified that you're going to be there. Mm-hmm. Secondly, it also, in my opinion, brings about the opportunity to rectify a situation in a business-like, congenial matter. It may be simply a mistake. People who are going to violate the rules of this to do the pollution on purpose are going to do it anyway, no matter how many times you go on there. So my situation in recommending this amendment is that you provide an atmosphere by this notification of settling or trying to, first of all, acknowledge the person's rights. Secondly, give an opportunity to settle it in a way that doesn't end up in lawsuits and conflict and all this other. And it there, as I said, it could simply be a mistake that can be rectified amicably and correctly. So I guess my point I think I made my point in doing this, and I've heard other good points, that yes, it may hamper in some cases, but in most cases where it's going to hamper your catching someone, that means that person has set their mind up to do it anyway. And it doesn't matter if you go on there unannounced, announced, whatever, they're going to eventually be back to it. So I would still stick to my recommendation that we do the notification. Thank you.
May I ask one question as far as that notification, written notification?
Documented notification could be, and I didn't define that because you get into some things. It could be by email because you have a record. It could be by phone, which you do a phone log. It could be by letter, by your choice, depending. You may have a situation where you can't email someone. You don't know who that is. Secondly, you may not be able to get them on the phone. It's very few and far between, but they may not have a phone. So, by letter, everybody probably has got a post office address. So, by whichever way that you can make contact and document that just for your records, your protection, again, the fact that your actions are not just arbitrary, that they're based upon best practices, and that I would feel would be another good reason, Justin.
Okay.
Commissioner Kaler, you're recognized for the second time, sir.
Thank you, Mr. Chairman. I very much appreciate Commissioner Lales and Commissioner Burkhalter's attempt to protect the right of the person that owns the property. I agree with that 100%. If you went back 24 months, how many times, I know you can't be terribly specific, but close, how many times have you been called to a piece of property with a complaint of some illegal action going on? Just ballpark.
Last year I received approximately, I believe it was 88 complaints that I investigated. Up to this year, this date, about 55.
And of those, how many were actual violations of the rules and regs?
Probably about a third of those.
And of those third, had they been given a 24-hour notice, would they have been able to pull the wool over your eyes and continue to do what they were doing that is affecting other property owners?
Probably anywhere from a third to a half, probably.
Okay, thank you.
Commissioner French, you're recognized.
Thank you, Mr. Chairman. I'd like to follow up a little bit on Commissioner Lales' line of questioning and whether you give them 24-hour notice or not, I mean, where the amendment passes. What happens when you go out there and the property owner says, get off of my property? I don't want you here.
I will leave. I will leave.
Okay, the board is clear on the amendment. Are the members ready for the question? The pending motion is to amend Section 11, providing documented notification to property owner 24 hours. Vote yes to amend Section 11. Vote no, not to amend. Please vote.
You have 10 yes, 8 no's, 1 abstain.
10 yes, 8 no's. The amendment fails. The pending motion now is to adopt resolution number 12-11-004. Mr. Folks, you're recognized, sir.
Thank you, Mr. Chairman. I have a question for Mr. Teague. The proposed resolution defines an urbanized area as one with a population of at least 50,000 and a density of at least 1,000 people per square mile. That's a quote from the resolution. Yet the map that you provided that purports to show urbanized areas shows the little town of Friendsville as an urbanized area. Now, according to the 2010 census, Friendsville has a population of 913 and an area of 3.2 square miles. Now, by my math, that looks like 286 people per square mile. Now, the resolution defines an urbanized area as 1,000 people per square mile. So how come the little town of Friendsville is considered an urbanized area on the map?
I can't answer that. I did not create the map.
But you follow that map. We established
Correct.
in our discussions before that you follow that map. Just doesn't make any sense. We write a resolution that says one thing, but the map that you're going to enforce against says a different thing. And I understand that this may not be your doing, but this sure seems like bureaucratic overreach when a resolution says one thing and a map that you're going to work to says a different thing. I think that's a big problem. Thank you.
Commissioner Burkhalter, you're recognized.
Thank you, Mr. Chairman. I would like to submit an amendment to the motion to strike Section 11 from the resolution. Good hearing, Mr. Chairman. I would like to make a motion to, or an amendment to the motion to strike Section 11 from the resolution.
Motion to strike Section 11. Is there a second? Commissioner Wright seconds the motion. The pending motion is to amend the resolution by striking Section 11. Discussion. Can we clear the board, Mr. Clerk? Okay. Excuse me. Now, I've reset the board. Anyone wish to speak? Commissioner Kaler, you're recognized, sir.
Yes, thank you, Mr. Chairman. In regard to Commissioner Burkhalter's request, if Section 11 was removed from this document, would you effectively be able to do what it is that you do in regard to our attorney's recommendation, TDEC's recommendation?
No.
In your opinion, would the removal of Section 11 be in contradiction? And I'm not trying to force you to make a legal opinion, but in your opinion, would it enable you to do what it is that you are responsible for doing in regard to TDEC's stipulations?
Yes.
I mean, I don't like it any more than anybody else. I didn't write it, but it is what it is. And again, I don't want to tell war stories, but I've been in your position many times. And I know that if people are trying to beat the system, if you're not allowed to do what it is we've hired you to do, then they're going to continue to beat the system. You know, it's not just about the person that owns that piece of property. It's about the people that own the property on the left and the right, the front and the back. Okay, thank you.
Commissioner Kirby, you're recognized, sir.
Thank you, Mr. Chairman. Mr. Teague, if this 11 was struck from the resolution, could you still go on construction sites and inspect and stuff according to state law?
Yes.
Okay, so if I live next to someone and I know they're doing things wrong and their sewer, whatever, battery acid, so forth, so on, is getting on my property, and I call you and you say I can't do nothing about it, what are my rights then to say that guy is putting this stuff on my property, and the back of my property, it's running down through the valley and coming in my property, contaminating my property, and I can't do anything about it except taking him to court and get me a lawyer, sue this person, because you're out of the picture. If living is done away with. So actually, we got a twofold thing here. We're trying to protect the commercial side, subdivisions and so forth, from those people trying to get out of there onto this farmer next door, that the other farmer sold his property to this guy. And then I'm out here in the county as a resident, and I got someone next door that's doing me in, and I can't do anything about it unless I just take him to court and sue him, and then the judge would have to decide who would the judge decide who would go in and say, you are wrong?
As far as I know, yes. The only other option I know that you have is calling TDEC, and usually they would say call the county or the city.
This whole thing is not for today. It's for today and from now on. And this population in this county is going to go on. It's going to go from 900 at Frenchville. It's going to go to 1,000 people in Frenchville. It's going to go in the metropolitan, in that close area. It's going to go. And somewhere these people have to be protected. We can protect them on construction and everything, but we can't protect one from the other, doing the wrong things. Thank you.
Commissioner Carver, you're recognized.
I guess when you do have to go on someone's property, are they receptive to your direction? I mean, is there a lot of people that are, you know, as they were saying earlier, get off my property, or is it mostly?
Very few have been aggravated at the situation or the fact that I'm there. Usually they realize that their neighbors complained and they show aggression to their neighbor, not to me.
Right. And majority is construction or just things that they're doing that they didn't realize was the issue, or that was an issue?
Most situations, yes.
Okay. Thank you.
Mm-hmm.
Commissioner Burkhalter, excuse me, Commissioner Wright hasn't spoken on the issue. Commissioner Wright, you're recognized.
I guess my question is for you, Justin. The scenario that Commissioner Kirby gave to you there, then the right thing for you to do, I assume, would be to walk down on his property and observe the violation. Now, that being the case, what would you do then? Would you call TDEC if Section 11 wasn't in there, or what would be your action?
Yes, I could inform TDEC about the situation. If I was allowed to access his property and document that way, then that's a possibility as well.
Commissioner Burkhalter, you recognize, sir.
Thank you, Mr. Chairman. I just want to make one thing clear. I am not opposed to crafting language that allows Mr. Teague or any inspector to do their job to protect us from illegal activity. What I'm unhappy about is having Section 11 that goes away from just grading permits, which is what the purpose of this resolution is, adding a more expansive clause inside of a resolution that 90% of it deals with grading permits. If Mr. Teague feels like he needs to have this ability to police and to go in for property owners that are not grading permit holders, then I believe Mr. Teague needs to come back with a new resolution to address that one specific area for us to debate at another time. We have a very tight time limit to pass this resolution. My question was if we can remove Section 11 and still pass TDEC, because we've only got 10 days or 9 days left to get it approved to TDEC. So I would like to see Mr. Teague back in front of us again with a new revised resolution that gives him the authority he needs to keep us safe from illegal activity, but I don't like the fact of it being in part of a bill that deals with grading permits. Thank you, Mr. Chairman.
Are the members ready for the question? The pending motion is to amend the resolution by striking Section 11. Vote yes to amend the main motion or to amend the resolution 12-11004. Vote no, not to amend.
You have 18 yeses, 8 noes, 2 absent. 11?
11, yes.
11, 8, 2.
Thank you, Mr. Clerk. The amendment is approved. Now the pending motion is to adopt resolution number 12-11004 as amended. Commissioner Burkhalter.
Thank you, Mr. Chairman. I'd like to propose an amendment to Section 4. I would like to strike from Section 4 the entire first paragraph that starts except as provided in Section 5. I would like to strike that entire paragraph and start Section 4 with the word any development. And now, Mr. Chairman, I have as a point of order, or as a point of clarification, I need to further amend Section 4. Do you want me to do that as a separate motion?
To keep everyone on the same page, Commissioner, I'd prefer that we take the striking of the first paragraph in your insertion
But I believe my insertion of what I need to add to the second paragraph is vital important to Mr. Teague as well. What I would propose is after the word of redevelopment in the second paragraph, after word number 4, we add in the language within the urbanized area of Blount County. So that way, the new paragraph after this motion to amend would read, any development or redevelopment within the urbanized area of Blount County that will result in a land disturbing activity, ... That's my motion, Mr. Chairman, to amend.
Mr. Wright seconds.
Mr. Chairman, may I discuss my motion to amend, sir?
In one moment, sir. I need to state the amendment, and I may, if you would...
I'll be glad to restate it clearly for you.
Thank you, sir.
My motion is to strike the first paragraph of Section 4 in its entirety and to add, after the word redevelopment, the words within the urbanized area of Blount County. That is my motion, Mr. Chairman.
Thank you, Commissioner Burkhalter. Now you're recognized for the purpose of discussion.
Mr. Teague, you've said that the whole purpose of this section was for construction activity on land of greater than 1 acre or each parcel which is what is in that second paragraph, correct?
Correct.
The way that I read paragraph 1, as it's written right now, is except as provided in Section 5, no person shall engage in any land disturbing activity. So if I take that section, that's applying to any land disturbing activity which you have defined as landscaping. There is no limiting clause in Section 5 for just construction or land over 1 acre. So it's my reading that section, that first paragraph and that second paragraph are contradicting each other, and to make the purpose of this resolution read more clearly, we strike the first paragraph. The exemptions that are stated in Section 5 are still valid exemptions from a grading permit. So by removing that language, we are clearly defining this resolution as applying to any development or redevelopment that will result in any development or redevelopment within the urbanized area of Blount County that will result in a land disturbing activity equal to or greater than, number 1, 1 acre in size of a project, but if the construction activities are part of a larger common plan. So that's what this limits to. It doesn't go to no person shall engage in any land disturbing activity. Mr. Teague, does that amendment violate or go against what we are trying to do with this TDEC proposal that has to be turned into the state within 9 days.
No, I don't think so.
Thank you very much.
Commissioner Farmer, you're recognized.
It's not on the amendment. I actually had hit my button earlier, and after this amendment's over, I'll still have the same question.
Are the members ready for the question? The pending motion is an amendment striking the first paragraph of Section 4 and then inserting after the words any development or redevelopment within the urbanized area of Blount County. Vote yes to amend the resolution. Vote no not to amend.
You have 15 yeses and 4 noes.
The amendment passes. The pending motion now is to adopt resolution number 12-11-004 as amended. Mr. Farmer, you're now recognized, sir.
Yes, sir. In line with the 2 amendments that have been passed, it was asked of Mr. Teague before the first amendment was passed, would that have any effect on whether or not it was approved by TDEC? His response was he wasn't sure, he would have to ask. If we're going to sit here and pass amendments on something in order to reach a time limit for it to be sent in, I think it'd be a very wise decision if we at least ask whether or not it's going to meet the muster with the state. Otherwise, we're going to sit here and amend ourselves out of it and end up fined again. We've been down that road before. And if that is the case, we at least need to get his opinion on whether or not it is going to meet the criteria. If his opinion is it does meet the criteria, fine. If it does not, but on any of the amendments that we're passing, I think on each one of them, Mr. Teague should at least give us his opinion on whether or not it will still meet TDEC criteria.
Commissioner Farmer, you may ask the question.
Why close the gate after the cows are gone, Mr. Chairman? We voted on 2 amendments. I had my button hit on both of them, and you know, I can only discuss the amendment that we are on.
Correct.
On the amendment of the deletion of item 11.
How did you vote on?
It's irrelevant how I voted.
Well,
that isn't the point, Mr. Chairman. The point is, I want Mr. Teague's opinion. Will we still meet the requirements of TDEC with item 11 deleted?
Mr. Teague?
I don't think so.
I don't think so.
I'm not TDEC.
Henceforth, we're going to pass something now and send down there within the time limit and be fined again.
Mr. French, you're recognized.
Thank you, Mr. Chairman. I have no amendments to make. I just have a few questions. Page 45, 3 questions.
Please.
Page 45, item U, it discusses impaired waters.
I'm sorry, I don't have the whole packet. Is it the resolution itself?
Yes.
What page of the resolution, do you know?
Well, it's page 45 in my packet.
Which section, Mr. French?
It's the definition section. Item U.
Okay, I'm sorry. Okay.
It discusses impaired waters. Can you explain what that means? And where it says failing to support one or more classified uses. And also, it says that these waters will be identified by TDEC. Where are they identified, and where is there a list somewhere that
There is. That's a newer definition that TDEC has created. That's why it's being inserted into this document. TDEC does make the determination on these impaired waters, and they make a list. It's every 2 years they come out with a list. Blount County, there's currently, I think it's 35 streams that are on this list of impaired streams.
And what does it mean by impaired is what I'm asking.
Being impaired,
Failing.
there's a pollutant in that stream of some sort,
Okay.
and it doesn't meet its recommended or classified use, whether that could be a drinking source, recreational, livestock watering, for example.
All right, thank you. The next question is the same section on definitions, and it's PP. Item PP, which Commissioner Foltz brought up. An urbanized area, land area comprising one or more places, which I assume are municipalities or I don't know. And the adjacent, densely settled surrounding area, urban fringe. Would you define what urban fringe means and how far out the urban fringe goes? Is it 5 miles from the city limit? I don't, explain what that means.
I don't have a definition for urban fringe. What I relate to is the map that I have for the urbanized area. And I know within that urbanized area map, it's where these regulations apply in regard to construction sites. It's the EPA and the census that have come up with these regulations, or I'm sorry, these definitions.
So you don't know if it's 15 miles or if it's 2 miles or
it would vary. I believe it would vary in every situation, in every location.
Okay. Okay, last question. Page 60. It's section, just a minute, I'm getting there. Section, well, it's section regarding inspections, site assessments. Let me see, section, I'm trying to find the section now. Section 8. And it's item, wish this thing were a little faster. Item, let's see. Item U, site assessment. And it explains, it states that under site assessment that a site assessment shall be performed for quality assurance of erosion prevention and sediment controls. The assessment shall be performed as per the Tennessee Construction General Permit, latest edition, at each outfall involving drainage totaling 10 or more acres or 5 or more acres if draining to an impaired or exceptional quality waters. Who performs this assessment? It doesn't say.
The engineer. The engineer that designed the erosion control plan.
Okay. Call. Thank you, sir.
Thank you. Commissioner Lewis, you're recognized.
Justin, this whole piece of work is not, I think we said it's been developed mostly for construction projects.
Correct.
But not totally. Correct? I mean, this seems to cover a lot more area than just construction.
What
In the
sections?
example Mr. Kirby was talking about, where if a property owner is dumping on another property owner, this is designed to handle that, correct? It's not just for construction project or construction development.
We have a separate resolution, totally separate from this one. It's been adopted, I believe, since 2006. It's an illicit discharge resolution. which gets more into detail in regard to illegal dumping, polluting of water bodies. So this is designed and geared towards construction. We do have another one directed for illegal dumping. That's been on the books since 2006.
Okay, but I don't see in here where it just addresses construction. The resolution says preventing the contamination of stormwater by grading, erosion, and sedimentation. It doesn't say by contractors. It doesn't say. So if you're what you're telling me is, if I have a neighbor who is dumping on my property, this doesn't apply to that at all. Is that what you're saying?
If a neighbor is dumping on your property, then no, this does not apply.
Okay,
I'm not a referee between neighbors.
Okay, if an individual is polluting a waterway, this does or doesn't cover that.
In what means are they polluting that water body? If they are grading and sediment is leaving their site into a water body, then yes. If they are dumping used motor oil, no, this one does not, but the illicit discharge resolution we have would address that. And we're talking about two separate worlds here, and everybody's going to get confused real fast, but it's a totally separate resolution.
That's the reason I'm asking, because I really don't want that confusion to be here. I want to make sure everybody understands what this one does and what the other one does, so that as these amendments are made, that we know what it is we're affecting and whether or not it's going to be covered by the other resolution.
Mm-hmm.
So if an individual is doing any kind of grade work on their property for their purpose, does this cover that? And the sedimentation goes into a waterway. Which of these is going to cover that situation?
The other one covers just about any pollution. This one deals with the grading type pollution.
Does the other one deal with grading pollution?
I believe it references the word sedimentation, sediment in a stream. Not necessarily grading, but it does reference, I believe, sediment or dirt in a stream. I don't have it in front of me, so I can't say all the different examples of the pollutants that it covers.
Right,
so I believe it does reference sediment still in that one as well. It doesn't reference grading, sediment. Sediments
that could be caused by grading.
Yes, it could be.
So where I'm confused is, what is the difference between these two?
This one is designed for construction sites that need grading permits and have to be inspected. It involves people performing grading activities that don't have permits that need one. It involves grading activities, even in situations they may not need a grading permit, they still cannot pollute by those grading activities within the urbanized area of Blount County.
Okay, so this covers mostly construction projects.
Yes, yes.
And in your opinion, if you strike Section 11, which we have done, it's going to affect your ability to perform this resolution?
If somebody's grading on their property, I have a complaint. Somebody's grading multiple acres on the back of their property. I get the complaint. I can't access the property to confirm that. I can't do my job.
So it has no teeth. Thank you.
Mr. Folks, you're recognized, sir.
Thank you, Mr. Chairman. I continue to be bothered by this definition of urbanized area. It says in the resolution, population of 50,000 and a density of 1,000 people per square mile, but the map that you enforce to, which you have given us, and it's not your map, it's provided by the census, I guess.
Correct.
Identifies a little town with 286 people per square mile, about a quarter of what the threshold is in this resolution, as an urbanized area. Now, here we haven't even passed the resolution yet, and we have a major point of confusion. On one hand, we're enforcing to a map which doesn't agree with what the resolution says. So I think in the spirit of making this definition of an urbanized area a little clearer, no one could seem to figure out what urban fringe meant. I'd like to offer an amendment to delete urban fringe from paragraph PP, the definition of an urbanized area. And maybe that'll make it a little clearer, since nobody knows what urban fringe means, and I'm very uncomfortable voting for a resolution where no one knows what the term means. Thank you. So I'm offering an amendment to delete urban fringe from item PP.
Okay, there's been a motion made and seconded by Commissioner French to delete item PP, definition of urbanized fringe. There's a second discussion.
Mr. Chairman, to be a little clearer, I want to delete the term urban fringe from item PP. I don't want to delete item PP. I'm just trying to delete the term urban fringe.
Discussion on the amendment to delete urban fringe in item PP. Commissioner Lael, you're recognized.
Mr. Chairman, my light was for another area of discussion. I'll pass on to the next.
Are the members ready for the question? Pending motion is to amend Resolution 12-11-004 by deleting urban fringe from PP. Vote yes to amend, vote no not to amend. One moment, clear the board.
Mr. Chairman, I'm sorry, I thought I left the lid. Mr. Teague, keeping with Commissioner Farmer's earlier request, does removing urban fringe violate the spirit of what you were trying to do with this resolution?
I can't answer that question. I did not create this definition, so I can't answer that. I don't know.
Then where did you come up with that word? Did TDEC give you that word?
Copied it from EPA in their stormwater guidelines.
All right, so that came from guidelines then from the federal government. All right, thank you, Thank you, Mr. Teague.
Commissioner Merle, you're recognized.
I was just going to ask if basically, we've run into this problem before in the last time that we came up with this, and Rockford was included in urbanized area. And I mean, the bottom line was they were going by the map. So even if we drop urbanized fringe, is it going to change who they include?
The map's still the map, and I don't see the map changing until the next census.
So it's okay. Thank you.
Commissioner Folks, you're recognized. You were.
I probably, okay,
Proceed.
I'm sorry, Mr. Chairman. Yeah, the map may be the map, but by deleting this urbanized fringe, it makes the definition in the resolution a little clearer. And if this is being misused and someone has to take it to court, it'll give them a little more support. And they can more clearly insist that the real definition be adhered to, because it'll be clearer. Thank you.
Are the members ready for the question? The pending motion is to amend Resolution 12-11004 by deleting urban fringe from item PP. Vote yes to amend, vote no not to amend.
You have 5 yes, 14 noes.
The amendment fails. Pending motion now is back to adopt Resolution 12-11-004 as amended. And I'd like to recognize Mr. Farmer.
Mr. Chairman, if I remember correctly, I voted in the affirmative on removal of item
Section 11.
Section 11. Therefore, I'd like to offer reconsideration of the amendment.
Been a motion made for reconsideration. Is there a second?
Second.
Commissioner Melton seconds. Discussion on motion to reconsider.
Yes, sir. Now, I would like to forward discussion on this. I have no problem with removing it if it is still viable and does not put us in violation with the state. However, what I would prefer to see done on this is to remove it pending Mr. Teague getting confirmation from the state that we are not in violation if in fact it is removed. Now, I understand we're on a time limit. I would love for us to have been able to have done this 2 or 3 months in advance, but obviously we're not at that point. And in hindsight and retrospect, I guess it bothers me if he stands and says he does not know if we're going to meet requirements if it is removed, and yet we still remove it. I've said here, Mr. Melton said here in years past when we did that and we ended up paying the piper for it. I want people to understand, if we go forward with this as it is and we remove it and it does not meet requirements, you better be ready to answer for it. So my reconsideration of this is that I request that it only be removed if Mr. Teague gets confirmation from the state that we are still in compliance. If we are not in compliance, then leave it in.
Okay, pending motion is a reconsideration of the vote on the amendment which struck Section 11 from Resolution 12-11004. Discussion, Mr. Burkhalter.
Thank you, Mr. Chairman. Mr. Teague, I've tried pulling up the permit guidance that you put in the initial packet from the state website. And it has listed on here permit requirements, section 4.2.4A, 4.2.4, 4.2.4. What section are we dealing with in this mass body of law that TFL?
In regard to the right of entry?
Or actually, originally regarding your original resolution, which the right of entry is part of.
Try to find that document.
Because I was thinking it was section 4.2.4, updates to construction site runoff control program.
That's it?
That is it.
Yes.
And then if, Mr. Chairman, I'm going to read a section from the state guidance on section 4.2.4.
Have request to read without objection. By unanimous consent.
Section 4. Thank you, Mr. Chairman. Section 4.2.4, construction site stormwater runoff control. MS4s, which I assume is Blount County, is that correct? We're in
Yes.
MS4?
Yes.
Shall develop, continue to develop, implement, and enforce a construction site stormwater runoff control program. Newly designated MS4 shall have this program implemented within 24 months of coverage under this permit. Is that where we are, where we're coming in underneath a newly designated?
No. That's for new MS4s. We've been here since 2003.
All right, so then we would be currently permitted MS4s then, is that correct?
Correct.
Shall continue to implement existing construction site stormwater runoff control program and must have any updates to the program complete within 24 months of coverage under this permit, and that's what expires on November the 24th.
Correct.
This program must address pollutants and stormwater runoff from construction activities that result in a land disturbance of equal to or greater than 1 acre. Reduction of pollutants discharged from construction activity disturbing less than 1 acre must be included in your program if that construction activity is part of a larger common plan or of development or sale that would disturb 1 acre or more. Would you agree that's what we've done with Section 4 now?
Yes.
The only section that I can see in scrolling through this is subsection H, procedures for site inspection and enforcement. The MS4 must have procedures in place for its inspectors to evaluate construction site compliance. The ERP must include specific enforcement steps to ensure construction sites are in compliance with the MS4 program. With the striking of Section 11, do you still have the ability to inspect and evaluate construction site compliance?
Construction sites, yes, but for a complaint on a piece of property where there's grading occurring for someone that was unaware that they needed a permit, have no access in.
That's right, you have no access. Now then, underneath your resolution, the inspector may institute, under Section 15, these are the powers that we are still granting to you. The inspector may institute injunction, mandamus, abatement, or any other appropriate judicial actions, or proceedings to prevent, enjoin, or abate the violation of any provision of this resolution or the provisions of any permit condition or limitation. So if somebody is grading 3 acres of property, they clearly are in violation of this resolution, correct?
If they're in the urbanized area, yes.
If they're in the urbanized area.
Yes.
Now, with the way you specified in the urbanized area, are you saying that Section 11 applies to people outside of the urbanized area?
No, because I can't issue a grading permit from those areas.
But you've already said earlier that Section 11 didn't apply to just grading permits. It applied to anybody that was in violation.
No, if I have a complaint regarding grading, there again, there's a separate resolution, illicit discharge, that deals with illegal pollution. It has a right of entry clause in there as well.
Right.
So,
but I guess
if I have a complaint, somebody's illegally dumping a substance in a stream.
That's not covered by this resolution.
In the urbanized area, this resolution, I'll leave it at the office. It does not come with me. A different resolution will pick that up. If I have a complaint about grading in the urbanized area of said number of acres, this is the one that applies.
And then that would not be covered underneath your notice of, I think it's Section 3, where if there is soil erosion or deterioration of the landscape, that you give 30 days written notice to come into compliance. Is that not covered as part of this as an existing eroding area?
That statement was put in there for projects that were, I guess you could say, grandfather when this first went into existence back in 2004.
I don't want to be fined by TDEC. I believe that from my reading of what we have from TDEC in the stormwater section, that the removal of section 11 is in compliance, but I am not an environmental attorney. I have not talked to TDEC about this, and I would rather I'm going to support Mr. Farmer's motion, his amendment, because I believe that we should be prudent at this time period. Thank you, Mr. Chairman.
Commissioner Samples, you're recognized.
Well, that's basically what I wanted to say too. I know a lot of us were here a few years ago when we were fined by TDEC, and we spent hours just like tonight, and we still got fined. I voted to take it out. Mr. Farmer makes a good point. I will be voting to strike that.
I understand you're supporting the vote of reconsideration. Commissioner Melton, you're recognized.
Thank you, Mr. Chairman. I have a problem too. I'm for leaving this in. And one big reason I am not for this amendment of 11 taking it out is because the thing you said, it hinders you from doing your job. That's what I heard, right?
Correct.
And we don't need to do that. I know there's a lot of things in this thing that we hear. I've heard a lot of discussions. People have opinions, and that you can ask different people their opinions. Even an attorney's got an opinion, but I think this is a good move.
Commissioner Lail, you're recognized.
Yes, sir. A couple of questions. As we've gone through all these discussions, it seems to me that we have been alternately going from discussion of construction to private property ownership. And we have a mixture of regulations here. My first question would be, what was TDEC's intent for us to do at this point? To ratify their stance on construction, or was it to ratify their impacting legislation on everybody? What is the intent of this, and that tells me what they will take or not take.
Commissioner Lail, at this time, we're trying to focus on the vote of reconsideration of striking section 11.
Well, I'm sort of getting there.
Your point's well taken, but the caption says contamination of stormwater by grading, erosion, or sedimentation.
I guess I'm asking for clarification here, which will indicate how I will vote on striking or not striking that particular item. Because if we're here and I want to know what their intent was. Are we just to deal with the problems created by construction, or are we just to throw out a widespread shotgun approach about anything that moves? Now, and let me finish, Justin. I know you're getting tired of standing there. You've been standing there a pretty long time. But we had, you said yourself a while ago, you have legislation and a resolution that deals with pollution in streams. Okay. And we would think that, am I to assume that would cover a private ownership, a violation unknowingly of one's rights over another? That doesn't apply to construction. That applies to that private ownership and so forth. So that's already in place.
Correct.
But in all our discussion, we seem to be mixing those. So if and you already have the right of inspection on those, correct?
Correct.
Okay. And by giving the permit, you already have the right of inspection on grading permits.
Correct.
So my question is, why is Section 11 essential if it's already covered? And that's where I was going, Mr. Chairman.
Mr. T.
I was going to say there again, if I get a complaint about construction without a permit on somebody's property, if I can't access that property to confirm that,
right,
then
not to debate you here, I'm trying to get a clear picture here, but if you had the other resolution that you said that indicated that any erosion, any stream pollution, etc., is impacted, wouldn't that automatically take you in that direction rather than, it doesn't matter what causes it, if I'm just out here scratching ground and I create a problem for someone else and they make a complaint, does that fall under the stream pollution resolution you already had in place?
Yes, I would think so, but that might be a question for an attorney. If we strike out the fact that I can inspect through this.
That's part of my confusion, because if you can remember all this conversation, we've been on both ends of the spectrum the whole time. And that's why I say, did TDEC want us to pass something just to be concerned with construction?
In this situation, section 4.2.4 is for construction, yes.
Construction only.
The number one pollutant in the state of Tennessee is sediment. And that's what they're after here in regard to construction sites.
So if we vote then to strike 11,
We have
because
voted.
of its broad.
We have voted to strike 11. We're now looking at reconsideration.
It's under reconsideration, I thought, Mr. Chairman. So is my conversation okay at this point?
Continue.
Thank you. If we are reconsidering putting 11 back in, okay, are we not kind of spinning in a circle because we've already covered it in two other resolutions, and what we've done is combined two concepts, construction versus private ownership and disturbance or violation, and try to put it all into one and made an all-encompassing process of inspection out of that. And that's what kind of bothers me, because most of the time that doesn't work too good, at least in my opinion. That's like a shotgun approach. And that's the point I'm trying to clarify. And if we go back to passing, as we did, the entire resolution that's before us, then we are either, we should be just considering construction, not private property. And that's where I think the problem is.
But construction,
we've got it mixed up.
Construction could be occurring on private property.
It could be, but any construction of that would have to be permitted, correct?
It should be, but it often happens.
If it's not, then that's an automatic violation.
But until I go inspect that property, I can't say that it is occurring to issue a violation.
Okay. See, we're kind of chasing our tail here. Okay, I understand. Thank you, Jason. Yes.
Commissioner French, you recognize, sir.
Thank you, Mr. Chairman. What I'm trying to understand,
the pending motion is reconsideration.
And what I think, I don't know if we're missing the point, or the way I understand this regulation is it is to control stormwater runoff, whether it's on a commercial construction site or whether it's on a private residential private residential site, as long as it disturbs 1 acre or more. Now, I think we're confusing construction site with commercial site. It doesn't make any difference. If the construction site is 1 acre or more, whether it's on a residential piece of property or a commercial piece of property, this resolution is directed at stormwater runoff. And I think what I'm hearing, some of these arguments, is that people we're trying to confuse construction site with commercial construction site. And a construction site, whether it's 1 acre or more, on a residential piece of property or a commercial piece of property, this addresses a construction site. Not a commercial construction site, a construction site on any piece of property in the urbanized area that disturbs 1 acre or more. That's the way I understand this resolution.
Correct.
Okay, thank you.
Commissioner Lewis, you recognize?
And I think even to make it more simple, is that Section 11 specifically addresses those who do not have a permit, and that gives you the ability to go on that site for those who do not have a permit to inspect.
Correct.
Is that correct? Thank
Correct.
you. I get it now.
Is there a there's a call for the question. Is there a second? Commissioner Harrison seconds. There's no debate. The pending motion is call previous question, which stops debate, and we move then to the vote of reconsideration. Vote yes to move the previous question. Vote no not to. A yes vote will terminate discussion. It will call the previous question. The previous question being a vote of reconsideration. Vote yes to move the previous question. Vote no to continue discussion.
Clear it and start again.
Pardon me?
You can clear and start again.
Let's clear and start again. Let's clear the board. Is everyone clear on the pending motion now is move the previous question. A yes vote will stop discussion and require immediate vote on reconsideration. A no vote will continue discussion on reconsideration. Please vote. Commissioner folks.
You have 17 yeses, 1 no, and 1 abstain.
17 yes, it requires 14. The immediately pending question now is a vote of reconsideration on the amendment to strike section 11 from Resolution 12-11-004. Vote yes to confirm let me get this said properly. A yes vote will uphold the amendment. Mr. Parliamentarian, help me out here. Reconsider the vote. So we'll be voting new on the amendment. It's as if the amendment had just been made, seconded, and stated. So if you vote yes, you're amending, you're striking 11. If you vote no, you're leaving the resolution with section 11 in. We're reconsidering the vote on the amendment. Is that clear? All right, I got the book. I got the book.
Yes puts it back, no takes it out, leaves it out.
I thought it was on the decision that it.
We're reconsidering the vote on the amendment.
But he was going to verify that it was, that TDEC said it was.
Vote of reconsideration is not amendable. Either. You can't have it both ways. You vote to leave it in, or you vote to strike it.
Correct. Yes leaves it in, no strikes it. Yes. Vice versa. No leaves it right where it is. Yes puts 11 back in. Yes.
Yes puts 11 back in, no leaves 11 out. Correct, sir?
It's just like voting on the amendment anew. Vote yes to put it in, vote no to take it out. It's as if we're putting the amendment back on the floor.
That's not what you said.
I'm sorry. I apologize. I've had my nose stuck in the book for 5 minutes.
Let's clarify this. Everybody is confused.
All right. A vote of reconsideration is made by one voting in the affirmative. Once you move reconsideration, you're putting the question back on the floor. The question was to amend the resolution by taking section 11 out. If you vote yes, you'll be taking 11 out. If you vote no, you'll be putting it in. You'll be leaving the resolution unamended. All right.
It's out. It's already gone. It's gone. It's not even there.
No, I beg your pardon.
Mr. Chair. Although I put it that way, I voted no not to take it out the first time. You're telling me now, I still don't know whether I vote no or yes.
I've got the votes. On the original, when it was originally on the floor, The motion passed, excuse me, come to order. The motion passed to amend it. And the amendment was to strike 11. We proceeded, we had a second amendment amending section 4. We had a motion of reconsideration of the question. When the question comes back up, we're voting on the amendment, the first amendment as it was presented to this body. I think Commissioner Burkhalter moved to strike 11, and he got a strike section 11 entirely. He got a second. We had discussion. The motion carried, which means it was struck. We're right back now to where the motion is back on the floor in its form. So if you vote again in the affirmative, you're striking section 11. If you vote no, you're voting against the amendment to strike 11, and it puts it back the way it was. That's my rule. Are we clear? Okay, I apologize. Vote. The call for the question is vote yes for the amendment, which would strike 11, which happened previously. Vote no against the amendment, which will leave it at section 11 in. If you vote no, section 11 is in. If you vote yes, section 11 is out. Please vote. Mr. Green.
You have 5 yeses and 13 noes, and 1 abstain.
The motion to reconsider the question passes. Section 11 is in. Now the pending question is to adopt resolution number 12-11004 as amended, and that amendment is section 4, paragraph 1 is struck, and the words added, you'll help me out, Commissioner Burkhalter, within the Blount County. Discussion on the main motion, Mr. Farmer.
In line with the previous amendment, without requesting an amendment to it, I would like to request that Mr. Teague confer with TDEC on item 11, come back to us and let us know if it is or is not required in this body of work.
Are you putting that in the form of a motion, Mr. Commissioner Farmer?
I honestly, in line with us voting on this, Mr. Chairman, if you'll help me put it in the form of a motion, I'll be happy to do so. Right now, all I'm just asking is a simple request of our stormwater director.
The request is in order, and if Mr. Teague will do that, we can move forward.
And then I think that will appease the other members of this body, and then we don't have to worry about being fined over it. If he comes back in 3 or 4 months and says, hey, they said we don't have to have it, then we can amend it, correct? Thank you.
That's, Commissioner Wright, you're recognized.
Well, it would appear to me that we've got more than just section 11. We've got a whole host of questions here that's not answered, so we need to do one of 2 things. We need to ask them for an extension of the deadline, if we can do that. Can we do that, Justin?
We can try.
Or we need to address all of the other concerns so we know exactly what we're doing and what we can do.
Come to order, please. Are the members ready for the question? pending motion is to adopt resolution number 12-11-004 as amended by striking section 4, paragraph 1 and making the insertion. Vote yes to adopt the amended resolution. Vote no not to adopt.
And you have 12 yeses, 6 noes, and 3 absent.
The resolution is adopted as amended. Next item of business is F2. The chair will stand for a motion on the budget transfer in the amount of $50,000, reference to drug court. Mr. Lewis moves. Is there a second? Mr. Carver seconds. The motion is to approve a budget transfer of $50,000. Discussion. The members ready for the question? Vote yes to approve the transfer. Vote no not to approve. Mr. Folks, Commissioner Carver.
You have 18 yeses.
18 yeses. The budget transfer is approved. Next item of business is F3A. The chair will stand for a motion on F3A. Excuse me, sir.
The board at first was showing Mr. Wells being absent when the board reflected he was back in the
Right, and his vote was recorded, wasn't it, Mr. Clerk? On the previous? Okay. Next item of business is F3A. The chair will stand for a motion on F3A, Resolution 12-11-002 to amend the general county fund budget by $62,385. Mr. Burkhalter moves. Mr. Kaler seconds. Motions to adopt Resolution 12-11-002. Discussion. Vote yes to adopt the resolution. Vote no not to adopt.
Yeses.
19 yeses, the resolution is adopted. Moving on to item F3B, the chair will stand for a motion on F3B, Resolution 12-11-003 to amend the general purpose school fund budget by $39,053. Lael and Lewis, motions to adopt Resolution 12-11-003. Mr. Folks, you're recognized.
Thank you, Mr. Chairman. Is Mr. Logan here or someone from the schools can answer a question on this?
Mr. Chairman, I'll answer the question on this. I think probably any question you have any member of the Budget Committee. Mr. Logan is out of town. I apologize, but I will try to answer it for you, Mr. Folks.
Okay. Last month, we were asked to approve a budget increase of $46,700 because the state mandated a special ed program had been overlooked in this year's budget. The money for that increase was taken from the electricity account of the schools, which we were told will probably have to be replenished with a budget increase later this year. This item, on the other hand, represents a windfall of $39,000 that came into the schools. Now, I would think that they'd want to put that right back in the electricity account, but that's not where it's going. And, you know, why not? Last month, It was an unexpected expense. You took it out of electricity. Why doesn't this windfall go right back in? And that's what I'd like an answer to.
Commissioner Farmer, would you like to answer that?
I'll attempt to. In essence, it's apples and oranges. The estimate included in the budget was $150,000. It actually come in at $189,053. It was special ed funding, therefore it was placed into instructional supplies for special ed. I'm not going to try to back up into last month's. I don't know what the different line items were last month. I can just tell you what it is this month. Now, you are strictly talking about two separate items, though, in referring to last month and this month.
Commissioner French, you're recognized, sir. I'll come back to you,
Okay.
Mr. Folks. That was a question and an answer. And let Mr. French have the floor. I'm sorry. Okay, Commissioner Folks, you're recognized. Thank you. Well, let me turn you back on now.
Thank you, Mr. Chairman. Well, that's a very unsatisfying explanation. We need money one month for a budget item that we forgot about, and we take it out of electricity. Now, later on in the year, no question, the schools will be back here looking to replenish that electricity account. Now, this month we get a windfall, and we don't replace the money in the electricity account. I don't like that kind of budgeting. I don't think any of the citizens like it. Thank you.
Are the members ready for the question? The motion is to adopt Resolution 12-11-003. Vote yes to adopt. Vote no not to adopt.
I have 17 yeses and 2 noes.
17 yeses, 2 noes. Resolution adopted. Next item of business, F3C. Chair will stand for a motion on F3C, Resolution 12-11-005, to amend the other capital projects fund budget by $150,000. I'm sorry, we've had a request to divide the question earlier, and I'll have to stand by that, sir. Do you move?
I'll move for approval of F3C.
Commissioner Burkhalter moves. Lewis seconds. The motion is to adopt Resolution 12-11-005. Discussion. Mr. Folks, you're recognized.
Thank you, Mr. Chairman. According to a very good report that our finance director gave us in the Budget Committee package, outlining how we're depleting the reserve funds of the county. This item and the next one will drain $175,000 more from our construction projects fund balance for these unbudgeted items. In just 5 months, we've taken this reserve from $605,000 to $212,000. We've used more than 60% of this reserve. At this rate, we'll shortly be out of money in this account. So I sure hope we've taken care of all the capital projects and that we don't have any emergencies in the schools, because this account will be depleted shortly at the rate we're going. I don't think that's a healthy situation, and we need to get better about budgeting these capital projects. Thank you, Mr. Chairman.
Are the members ready for the question? The motion is to adopt Resolution 12-11-005. Vote yes to adopt. Vote no not to adopt.
I have 18 yeses and 1 no.
Resolution's adopted. Moving to the next item of business, F3D. The chair will stand for a motion on item F3D, Resolution 12-11-010, to amend other capital projects fund budget by $25,000. Mr. Burkhalter moves. Mr. French seconds. The motion is to adopt Resolution 12-11-010. Discussion, Mr. Folks.
We're facing a tight budget year coming up here. This item takes $25,000 from a reserve fund we were just talking about to build bleachers or to replace bleachers. Do bleachers wear out? Why are we replacing these bleachers? Particularly in the light of how tight things are in the budget for the schools. Should we really be spending $25,000 on bleachers? Thank you, Mr. Chairman.
Commissioner Farmer, you wish? Are the members ready for the question? Motions to adopt 12-11-010. Vote yes to adopt. Vote no not to adopt.
We have 17 yeses and 2 noes.
17 yes, 2 noes. The resolution is adopted. Next item of business is F4. Pursuant to action taken by the Agenda Committee and this body setting the agenda, the chair now recognizes Blount County Schools Director, Mr. Rob Britt.
Thank you, Mr. Chairman, Board of Commissioners. Gee, I know how happy you are to see me after all of that right there. But I'm pleased tonight to give you a very brief briefing on the state of the schools, both from an effective and an efficiency way. So without any further ado here, as you know that we were named one of the exemplary school districts in the state, and we want to again thank you for the proclamation and the recognition that we received from this body back in September. How we were able to do that is that the school system met the vast majority of their annual measurable objectives in achievement, and we closed achievement gaps for the majority of our subgroups. And so, in other words, we grew faster those students who are furthest behind. We grew them faster than the overall group in order to close that gap. And so that's how we were able to do that. The next slide, you'll see both in math, English language arts, and science, you can see how that stair-stepped over the last 3 years and how we have progressed in each one of those subject areas over the last 3 years. And also, in the last bar, you can see it compared to the state average, and we're above state average in all 3 of those major areas in grades 3-8. The next slide happens to be high school. High school improvement, again, we're either at or above the state average in those 5 EOC subject areas. It also breaks it out by high school in case you're interested in seeing how that looks. That's achievement side. In terms of the value-added side of academic growth from year to year by individual student performance, I've given you a composite of all 4 subject areas in our elementary schools. And I want to just remind you that 0.0 is the full year's or 100% growth for the year, and that would be considered the minimum growth standard in the state. If you saw a slide from a couple of years ago, you'd see red. You'd see some schools did not post even to the minimum growth standards. And this year, 2012, you can see every elementary school was above the 0.0. And the majority of our elementary schools exceeded the growth standard significantly by having a +2 or better, which in the state's accountability model would be considered an A. And there it is for middle school. Again, all of our middle schools are performing above the minimum growth standard in all 4 subjects. Out of 169 schools, we had 4 of our schools that were recognized as reward schools. Carpenter's Elementary School is one of the top performing schools in the state, top 2%. Not only did they make it in the area of achievement and performance, but they also made it in the area of progress, which is value-added growth as well. Friendsville and Union Grove Middle, as well as Walland, also made it for progress over the course of last year. Our report card has come out just recently, and you can see that we had straight B's in our achievement side, and then A's in our writing, and then in value-added growth. And this is a 3-year average. It's not just based on 2012, but a 3-year average and where we are. In fact, we increased our mean score in all 4 subjects. Doesn't mean necessarily that the grade goes up, because you have to have it at a certain level in order for that to happen. But we did improve in social studies from a B to an A, and so we're making some really good progress. 2010 is our worst year in reading, language, arts, and science, so we really look forward next year as we get to 2013 data. We really believe those grades will rise there as well. This is also a 3-year average of our ACT and grad rate report. The ACT, as you can see there, we were wanting to be certainly above a 19 in all of our subjects. Of course, our long-term goal is a 21, so you can see we have some challenges there. Our 2012 graduation rate rose from 90% to 90.6% in 2012. So again, good job on our parts of our high schools. I won't read these, but these are in your packet. They're just general observations that have been made from the student achievement data that you're looking at tonight. College readiness benchmarks, what we look at in terms of growth in those areas. 8th graders take the Explore test, and again, you're looking at 0.0 being a full year's growth, and the minimum growth standard. And you can see that in Blount County, compared to the 8 school systems that are most similar to us, that we are either at the top or very near the top in all of our subject areas as it relates to the Explore test. And then the plan, this is our 10th graders. Our 10th graders take the plan. I believe our composite score was higher than the 8 similar systems, and overall an outstanding job on the part of our 10th graders. And then this is our ACT, and we couldn't compare to the 8 other systems because that data is not available to us that we can see there. So we took 2011 on the left-hand side of the chart, and you can see that in compared to 2012, how much growth has occurred over that period of time. So that's really moving us in the right direction as it relates to our students' college readiness. That's just a briefing on our achievement side. Now we're going to look at the efficiency side. Let's take a look at the numbers and how we're funded. As you know, that 99 cents was 1112, and we moved that forward without any additional cents allocated to schools. The breakdown also remained the same. Out of that 99 cents, Blount County schools only received 62 cents. Maryville, about 27, a little bit more than 27, and then Alcoa right around 10 cents. It's just another way to look at it, but I think it's a good way to look at it. A lot of people don't understand split dollars. I think it's important for people to understand it because what this body allocates for schools is 99 cents, but the Blount County school system only get 61.6 cents of that. And Maryville City gets 27.6, and Alcoa gets 9.9 cents of that 99. Another way to look at that is right here, as you can look and compare the three school systems here in our county. Blount County, of course, getting that 61, and that's all we get. We don't have another source, and so you can see Maryville City, actually what they provide, Maryville City, is 65 cents, and then we add that 27 cents on top of it in order to get 92 cents for Maryville City. And then Alcoa City provides about 90 cents, I believe it is, with another 10 cents on top of that to get them to that $1.03 average right there. Here's how we, the allocation breakdown of where the money comes from that funds our school systems. As you can see, locally we're at about 38.3%. That's both property tax and sales tax together. And then also 50% coming from the state, about 11.3% there from the federal government. And then you can read on your own about Maryville and Alcoa and how where their funding comes from. And I thought it was interesting, though, that our federal funding is just about equal among the three systems. Not a lot of discernible difference there. You know, if you compare the 8 systems most like us, I think it's interesting to look at this graph that our current property tax rate at 215 is right in the middle of those eight counties. And if you break that down and you take a look at what our allocation is from that tax rate and compare that to what is allocated out of the tax rate of those other school systems that are most like us, you can see that we're almost last. We're down at the bottom at 61 cents for the Blount County schools is allocated for us in comparison. And that would, if you look at that by percent, the actual percentage of that property tax rate to schools is right around 28%. And it's dead last among the 8 most similar systems in terms of enrollment and demographics. You can see that we continue to make adjustments to and cost-cutting measures. I think you can take a look at where we peaked at about 720 teachers in 2009 and where we are in comparison with 682 here in 2012-13. You can see that we're flat on the number of principals. We haven't added any of this year, although our schools are up. How many schools are actually serving and students? Schools to supervisors, as you can see, we're dead last among the 8 most similar systems with 8, with the average around 11.6. By the way, I want to remind you that the BEP funding formula actually funds up to 15 supervisors for our school system, but we choose to use that money to better serve our students at the school level. But I think that this is an interesting chart as people take a look at spending, I think is very important in what we're trying to achieve. We have 21 schools, and you can compare us to the other 8 school systems and how many schools are actually serving their students as well. And then I think that, for the most part, a lot of times, and you can see that we're extremely cost effective with what we have, and you can see that we've been very effective. But I think that one thing that we have to be guarded about is, well, they're doing great with what they've got. Why do they need? Why on the earth would they need any more? Well, it's because for every year that we move forward, our annual measurable objectives will continue to increase, and our challenges will continue to increase. Just the same as we move toward the implementation of Common Core standards and the PARCC exam, the metrics is going to change. And let's take a look at this graph right here. As good as we're doing, our 3rd grade readers across the county, system-wide, only 47.5% of our 3rd graders read at a proficient level or above. Now, that met our AMO for last year, and it also is above the state average. But we're not satisfied with 47.5% of our 3rd graders reading proficiently. And as we make the move toward college readiness, we have to do a better job related to that. That's a huge and major challenge, the kind of resources that are needed to move those struggling students to that bar is going to increase. Here's another. We're looking at the other end. We looked at the bottom end now, at the third graders. Look at this end. This is one of the very few metrics in the entire accountability system that you're going to find us underperforming the state. But it's an important one. If you'll take a look over the last several years, we have not been meeting or exceeding the state average in terms of a college going rate. This is the number of students that are leaving our high schools and going to a 2 or a 4-year school. And I think this year we were right around, I believe it, I can't read it from here, I think it's 43%, 46% actually, compared to a 57% in the, at the state level. And again, we have to, and I think you saw on the college readiness exams, we've got kids in the pipeline that are going to be very well prepared to go to college. We have to do a better job about getting them there. Major challenges, we are dealing with unfunded mandates. Not just us, but many school systems across the state. And I'm not going to read this whole chart, but one I want to point out to you is the full implementation of the Common Core state standards. This comes with training and textbooks and materials and resources that are desperately needed in order to fully implement those and to be successful with those in terms of moving our students' achievement forward. But the state has not provided any additional funding to help us with this. Transition to online testing, I think most of you know about that and the kind of challenges that brings up. And basically the bill for that's not here yet. But when it gets here, basically it's going to come down to a decision. We either do it or we don't. And then what's the consequences if we don't? Teacher and principal evaluation system continues to be something that we're going to see that we're going to have additional expenses as a school system. And then I'm going to let you read down through there, but I will say that the Tennessee Diploma Project, our current level seniors are in their 4th year of math. And the reason that they're in their 4th year of math is because we found other ways than to ask for additional teachers. We changed our schedule. We got creative. We reallocated some positions from attrition to math. We did some things so that we could be ready for that. But as our students matriculate through the grades, this is going to become more difficult, especially in the area of foreign language. We don't have enough foreign language teachers this year as it is. We've had to put off foreign language for certain students. Some students will have to start it later. Some students, if they failed the course, can't have it this year, so they'll have to wait till their senior year to get it because we don't have enough teachers in that particular area. I don't know if I mentioned to you, but I want to mention to you that our school system is having to deal with a lot of unfunded mandates. In conclusion, the Blount County schools are meeting our stated goals in a cost-effective manner. Our system is efficient and effective. Isn't that what we all want? I think that's what the public expects, and I think that's what the public is getting from the Blount County schools. I'm proud of our schools, and I believe you're proud of our schools. I hope you are. You certainly should be. I believe that this is one of the best bargains you could find anywhere in the state is right here in Blount County. Our challenges require additional investment. I'm not going to apologize for that. So that our teachers and students have the technology and the instructional resources that they need to continue to improve and meet higher standards. Although we've been successful at growing students academically and improving achievement, we have a long way to go to attain the kind of progress associated with college and career readiness. We need your help. We can't do this alone. Everybody in this room is a part of raising up our community, raising up our children, and providing them with the best possible education that we can afford. We will need your help in this journey to successfully ensure that all of our students, and I mean all, reach educational excellence. Thank you. I appreciate your time tonight. Thank you, Mr. Chairman.
Turn my mic back on, then I didn't vote.
You have 18 yeses.
18 yes, 0 no. The resolution's adopted. Next item of business is F6. Chair will stand for a motion to set a public hearing for December the 11th, 2012, 6:30 p.m., room 430, Blount County Courthouse, for the purpose of hearing testimony and comments regarding a resolution to amend the zoning regulation of Blount County, Tennessee, by adding a new section, 7.18, Design Standards for Commercial Campgrounds, Recreational Vehicle Parks, amending sections 9.1B, 9.2B, 9.3B to include commercial campgrounds, recreational vehicle parks, and to amend section 13 to include definitions for camping cabins and commercial campgrounds. Mr. Kirby moves. Mr. Commissioner Wright seconds. Vote yes to set the public hearing. Vote no not to, excuse me. Commissioner Folks, you're recognized.
Thank you, Mr. Chairman. This resolution has been a source of considerable controversy in this community. It's the 5th time it's come up. I think it's unfair to the citizens to hold this hearing during the holidays, and I propose that we amend the motion to hold the hearing in January when our citizens can more easily attend.
There's a motion to amend the date, the month. Is there a second? Ms. Merle seconds. Could Commissioner Folks be more exact on the date? Ms. Pitts, can you give us a date for January? We need a date certain. January the 8th, at the same time and place. The pending motion is to amend the hearing date to January the 8th. Discussion on the question. Pending motion is to amend. Vote yes to amend. Vote no not to amend. Please vote.
You have 7 yeses and 10 noes and 1 abstain.
The amendment fails. The pending motion now is to set the public hearing December the 11th, 2012, 6:30. Discussion on the main motion. Mr. Folks, you recognize?
No, I'm not.
Sorry. The members ready for the question? Vote yes to set the public hearing on December the 11th. Vote no not to set.
You have 14 yeses, 4 noes.
Public hearing is set. Item G, announcements and statements. The commissioner need to be recognized for an announcement or statement. Seeing none, moving on to item H, public input on items on the agenda. Ms. King, if you'll come forward.
I'm Linda King in District 4. I hope you realize that you received a mandate from the citizens of Blount County. They didn't want a wheel tax and they don't want an increased sales tax. People are fed up with the idea that spending can remain constant while more can be taken from the pockets of your constituents. It's time to tighten the belts of our bloated government and to drastically cut the budget. We're hearing again that the school system is in dire need of more money. Well, as I've said before, nothing is mentioned about buying a new car for the director of schools or giving him a raise far above the percentage of anyone else in the county. That sure wasn't for the kids. Has anyone checked into the amount of money used by the education PAC to fight for more sales tax? Huge ads in the paper and a billboard couldn't have been cheap. And this comes from the same group of people who claim they don't get paid enough. That large sum of money could have been spent on technology updates for which they so desperately plead. Because I don't see you commissioners at school board meetings, I have to relate a story that has astounded me. One night, Dr. Bell stated to the board that there was money left over from the construction of a new school. So he excitedly announced that they'd be able to contract for a mural to be painted in the entryway, add pillars along the drive, and instead of regular fencing, could add ornamental fencing and electric gates. I was mortified. That unused taxpayer money could have been used for construction projects at other schools, not spent on superficial extras. But I guess when you're spending other people's money, money that is part of our $250 million debt, it's no problem. After all, we'll just ask the commission for more later down the road. I was educated in a school building resembling Rocky Branch and Chilhai View, and I got a great education. We were taught about the history of our country, the Constitution, and learned to write in cursive. The school wasn't pretty, nor did it need to be. Sex education took place at home. We carried our lunch to school, and sports activities were voluntary and paid for by parents. For some time, we've had football and basketball coaches, but since when do we need dance coaches, tennis coaches, and a bowling coach? We need to get back to basics. Nowadays, we see kids unable to make change for $1 when a cash register malfunctions. I've heard one particular commissioner rave about the beautiful school that was just built. Maybe it's just me, but I'd be more impressed if I saw fiscally responsible spending and less debt left for our kids. Thank you.
Seeing no hands, Chair will entertain a motion to adjourn.